Good afternoon, everyone. My name is Andrew Taylor, and I am a family law attorney at Shemtob Law in Blue Bell, Pennsylvania. Welcome to the fifth and final of our teleseminars for Uncoupling, the Divorce Resource Group of Philadelphia. Today's title of our program is called Life After Divorce, Now What? So today we're going to address issues that arise after your divorce is done. Thank you all for tuning in and listening. Just a little bit about us. Again, our name is Uncoupling, the Divorce Resource Group of Greater Philadelphia. We're a group of 10 professionals designed to provide information drawing on our particular area of expertise as it relates to the divorce process. We are committed to providing information and giving guidance to people who are navigating through the divorce process. Our goal with these teleseminars is to provide knowledge and dispel some of the many myths surrounding divorce. We are not offering advice during these teleseminars, but we are helping people educate themselves about the process. With this group, we wanted to create a one-stop shop of professional resources for all issues that might arise during the different stages of divorce. So let me introduce the members of our group. Again, my name is Andrew Taylor, and I'm a family law attorney at Shemtob Law in Blue Bell, and I practice law in Montgomery County, Philadelphia, Bucks, Berks, and Chester counties. We have Alexandra, or Allie, Collier. She's an insurance account executive at Johnsel, Kendall & Johnson. Liz Butler, clinical social worker and therapist. Sheila Brennan, who is our divorce coach. Valerie Clark Roden, who is a client relations manager at Hoteling Investment Management. Mark Bradford, our forensic accountant, and he's at Asterion Consulting in Philadelphia. Laura Stagosi, who is an estate planning and attorney at Diamond, Polsky & Bauer. Bill Donahue, who is a mediator and attorney and owner of Transitions Mediation Center. Ken Feynman, branch manager at Approved Mortgage Group. And finally, Kay Pugh, who is our realtor, and Kay works at Keller Williams of Bryn Mawr. Our previous teleseminars dealt with knowing when it is time to separate, the financial issues that surround divorce, child custody issues, and life in limbo, which means during the separation period when you're not yet divorced but separated. If you want to listen to any of these teleseminars, you can go to our YouTube channel, which is Uncoupling Philly Divorce Resource Group. If you want to contact any of us, you can find our information at uncouplingphilly.com. We hope that these topics covered several frequently asked questions that typically arise during the course of a divorce, and hopefully provide some guidance to our listeners. So, without any further ado, let's start today's program. Again, today's teleseminar is going to deal with life after divorce. So we're going to discuss some common issues that arise after your divorce is finalized. And I'm going to start off today. And many people think that once you're divorced, you're done, and you don't have to deal with your ex-spouse anymore. Unfortunately, for many folks, that's not the case. And when we were discussing this teleseminar the other day, I kind of went through my active files and clients right now, and I think about half of my clients are actually already divorced. So that might be some bad news for people that think there is this light at the end of the tunnel. But unfortunately, issues do arise after a divorce decree is entered. So I want to just go through a couple of issues that pop up. First is enforcement of property settlement agreements or marital settlement agreements. So just by way of background, a property settlement agreement is a comprehensive agreement that a husband and wife would sign, dividing up assets, dealing with alimony. Some deal with child custody or child support. And that agreement is ultimately incorporated into the divorce decree, which means that it actually becomes an order. So these agreements, you need to have one if you settle out of court. You have to follow them. They're not optional. And to the surprise of no one, oftentimes they don't get followed to the T. So what we find ourselves doing a lot of times is filing a petition to enforce the property settlement agreement, which can actually be a petition for contempt because, it kind of merges into the order, which is the final divorce decree. So, for example, if there's a provision that divides up assets, requires one party to refinance the house and pay the other party a lump sum of money, and that doesn't get done within the time specified, you'd have to file a petition to enforce. and go to court if necessary in order to force the other party to do that. Now, Bill is going to talk shortly about mediation and the role that that plays, and I often refer clients during the entire course of a divorce, but especially after a divorce, to go to mediation and not run up unnecessary counsel fees and hopefully get things done quicker than if you would have to go to court. And one final note about property settlement agreements. Oftentimes, there is a provision that requires the breaching or non-complying party to pay the counsel fees of the other party. So that's something to be cognizant of. So if you do have to go to court, you can always raise a claim for reimbursement of counsel fees because now you are enforcing an agreement. Next is child support and alimony. So just a note about child support. In Pennsylvania, child support is payable to the recipient spouse until the child is emancipated, which is graduation of high school, or when the child turns 18, whichever occurs later. Until that time, child support is always modifiable. So not most, but a lot of people come in and think that once you have your child support award, that's what the number is until, forever, until emancipation, and that's not the case. If there's a substantial change in circumstances of the incomes of the parties, either party can file a petition to modify. In Pennsylvania, support is based on guidelines, not need, so it's basically driven by the incomes of the parties. So oftentimes you'll see if someone gets a raise or a big bonus, you can always go back and try to modify the number up or down. Another issue that pops up with child support is enforcement. So if the spouse that is to pay child support chooses not to, then through domestic relations of your county, you can institute enforcement proceedings where the party will be compelled to pay, because again, child support, just like property settlement agreement, obligations are not optional, they are mandatory. So if someone falls behind in arrears, you can go in for enforcement proceedings, and there's a whole host of remedies that you can ask for, and of course the big one is incarceration. You see the deadbeat dads, for lack of a better term, get locked up every now and then in the news when they do these roundups by the sheriff. So that does happen. But that's an issue that often comes up after a divorce is done. Reimbursement of medical expenses for the children, you go through domestic relations for that as well. Alimony can be modifiable if it says so in your property settlement agreement. Sometimes it's non-modifiable. And for alimony, you're looking at not just the incomes of the parties, but actual need. So if your need as the recipient spouse of alimony increases, like if you unfortunately have medical expenses that would increase, you can always go back and ask for more alimony. So these are things that, again, occur after the divorce is finalized. And finally, custody, child custody, is always modifiable. And it's noteworthy that for custody, you don't need to prove a change in circumstances. It's always modifiable no matter what. And we did a previous teleseminar on just custody issues, so I would refer everybody to that. And in that seminar, I explained the many factors that a judge has to consider in determining any award of custody. And as the children get older, their preference definitely holds more weight with a judge. So that's something to think about as well. Just because you have a custody order in place when you're divorced doesn't mean you're stuck with it forever. And of course, enforcement of custody orders, you can do at any time as well. So those are just some of the issues that come up. And like I said before, a lot of times I'll refer these cases to mediation. And I would like Bill to talk about that at this point. Bill, can you introduce yourself, please, and tell us a little bit about what you do?
Sure. Thank you very much, Drew. I am a divorce and family mediator. We mediate really all aspects of divorce and family law. Before, during, and after divorce, I've been doing mediation for about 20 years, and I've been a divorce lawyer for about 25. I practice in the Philadelphia metropolitan area, including South Jersey. So that's what I do. I want to talk a little bit about how mediation relates to those issues that you were just talking about, Drew. These, for our purposes, for mediation purposes, they sort of fall into two large categories. The first one involves money, and the second one involves what we often refer to as lifestyle or quality of life issues. The money issues are the ones that you were just talking about, Drew. child support, alimony, and equitable distribution. We tend not to do so much equitable distribution issues in mediation, although we certainly can, but the support issues we do all the time. Where the issue comes up is when support is not being paid or when support needs to be changed, and they're really a question of enforcement, which is when it's not being paid, or modification when there's a change. When there's a change in circumstances financially, so it becomes appropriate to change support, the process of going through the court system to do that can be time-consuming and expensive. So what we do is sit down with the couple, and they talk about it and talk about how things have changed and why things have changed. It's a very different process when they're sitting there talking to each other and trying to come up with something that works, and sometimes they simply do what the basic guidelines provide, and sometimes they do things that are different. But the goal here is to help maintain the relationship between them so that the money issue doesn't erode their relationship as parents, as ex-spouses. So they're the financial issues. The other part that I mentioned before are lifestyle or quality of life issues. After a divorce, particularly if people have not been separated for a long period of time, the parenting plans that they put in place are not often ideal because they don't know what's going to be ideal, and they need to be changed. In New Jersey, it's a little different. We do need, in the court system, to demonstrate a change in circumstances before we can seek a change of custody through the court system. But in mediation, when a custody arrangement is not working, people can sit down and talk to each other and try and figure out why it's not working, and then come up with, sometimes it's a tweak here and there, sometimes it's a whole revision of a parenting schedule. This is particularly helpful 6 months out after the divorce, a year out after the divorce, when the things that they thought would work just aren't. And then there's something else that is really important and that we mediate all the time. For children to do well after a divorce, to thrive, they need consistency in their households. If their lifestyles are dramatically different from one household to another, it's not good for children, and the court system does not want to be involved in things like, when do your kids go to bed? How often can they play video games? What kind of meals do they eat, and when are their meal times? What curfews do they have? What sports clubs, activities? What kinds of things like that are they involved in? They cause real disputes between parents, and sometimes in one household kids will go to bed at 8 o'clock and in the other household they go to bed at 11. If you have people who are not talking to each other or are talking very angrily to each other, it's very, very difficult to iron out these things, and you really can't go to court and say, my spouse lets the kids stay up until 11 o'clock. The judges simply, or masters simply, don't want to hear that. So the question is, how do we address those issues in mediation? What I have found over the years is that those issues really are not about the dispute that they're having so much as they are about residual anger left over from the divorce, anger, hostility, resentment, fear, all kinds of things, sometimes even jealousy. But it's those underlying emotions that motivate people to say, well, I don't care what time you put the kids to bed, I'm going to do it my way, and no discussion. If people are able to sit down across a table from each other and talk about those emotions that are motivating what they are doing, so often they begin to realize, first of all, that what they're doing is not making them happy, but also is really bad for their kids. So what I encourage to help them get past the habitual fighting and bickering and all that leads to these fights and disagreements is to have a really frank discussion about why they're angry and why they're hurt. It's not therapy. It's not to resolve the underlying emotional issues so much as to help them understand why they're treating each other the way they are. And I find that having that discussion goes a long way to having them say, okay, well, let's iron out these problems that we have. And the other thing that I talk to them about and ask them to discuss themselves is the impact that their constant fighting over little things is having on their children. And when they begin to see what it's doing to their children, they really make an effort to stop what they're doing. So that's how mediation can help people with these issues. I just say to them, you know, are you happy with the way things are? And if not, what can we do to change it? And for most people, once they can get past the anger and the hostility, they're able to address these issues in a rational way and resolve them.
All right, great. Thank you
Thanks,
very
Jeff.
much. Good advice for sure. I want to turn it over to Laura. Laura, can you please introduce yourself and tell us a little bit about what you do?
Yes, thanks, Drew. My name is Laura Stigosi. I'm a trust and estates attorney with Diamond Polsky and Bauer in Philadelphia, and we also serve the surrounding counties of Philadelphia as well as New Jersey. I deal a lot with estate planning, so the preparation of common estate planning documents, and also with estate tax and inheritance tax issues.
Okay, Laura, can you tell us why it's important to review your estate plan once the divorce is final?
Well, in my mind, a divorce is not complete without a review of your estate plan and an update of your documents. When people hear the term estate planning, they often think that they have to have great wealth in order to put a plan in place. And at the end of a divorce process, a person might feel like his or her assets have dwindled because of payments due to an ex-spouse or legal fees incurred in the process. They might even think, why do I even need a will? Well, first of all, everyone has a will, whether it's the will that you write for yourself or the will that the state in which you reside writes for you, meaning that if you do not put in writing your desires for what happens to your property at your death, then the laws of the state where you live control. So wouldn't you rather control who receives your property and who's in charge of the disposition of your property instead of having the state's laws decide for you? Second common misconception is that an estate plan involves just a will. In reality, it also involves appointing someone to deal with your finances should you become incapacitated, and it also involves appointing someone to make medical decisions for you if you cannot. So it's more than just having a will updated. And third, your property settlement agreement might require that you set up a trust in your will, or might even require a separate standalone trust document for your children so that life insurance proceeds can be managed properly upon your death.
Okay, thanks, Laura. What are the important documents a person should have as part of their estate plan?
Well, I think that there are at least 3 to 4 documents that are important to have, and this is at a minimum. The documents are a will, a power of attorney for financial purposes, a healthcare power of attorney, and a living will. And I'm going to briefly explain each one. So most people are familiar with what a will is. It's a document where a person expresses what they want to happen to their assets upon their death, and the person also appoints somebody to deal with those assets, to manage the assets. And that person is known as the executor. So that is a document that takes effect at death. In contrast, a power of attorney for financial purposes is a document that's in effect only during your lifetime. In that document, you appoint somebody to manage your assets for you, and essentially they step into your shoes and can do whatever you could do with your assets. But it takes effect either as soon as the document is signed, or a power of attorney can also spring into effect upon an event like the incapacity of a person. And I tell people that the power of attorney document is a document that you grant somebody broad-ranging power to deal with your bank accounts, your real estate, and your other financial affairs. So you really have to choose somebody who you trust and who's responsible. Moving on to the third document that I think is important, that's the healthcare power of attorney. And that's where a person names somebody to make healthcare decisions for their benefit if they cannot. So if you can consent to surgery, then you can do that yourself. But I can typically think of a situation where a person is in an accident and they are unconscious, they can't make healthcare decisions for themselves. So that's where the power of attorney for healthcare comes into play. The person they name in the document will consent to surgery, will admit them to the hospital, will also have access to the healthcare records, and that's if a person cannot do that for themselves. And finally, the last document that I think is important to have is a living will. That's the document where a person expresses their end-of-life wishes for care if they're in a terminal condition and they cannot, and they're permanently not able to communicate what their wishes would be for that end-of-life care. So you can appoint somebody to make those decisions for you or communicate those decisions if you cannot.
All right, so as a family law attorney, I field a lot of questions that I can't answer about changing those documents that you were just talking about before the divorce is final. Can you talk a little bit about that, please?
Sure. Well, I think it's important to speak both with your estate planning attorney and also your family law attorney about this early in the divorce process. You may want to change your will before divorce. So if you die before the divorce decree is issued, your spouse may still have control over your estate and may be entitled to your assets. In Pennsylvania, you cannot completely disinherit a spouse before you are divorced, but you can significantly reduce the amount that he or she may receive should you die before the divorce is final. And one way to do that might be through changing the provisions of your will if everything is now stated to go to your spouse. If you've named your spouse as the executor of your will, you would probably want to change that as well. The executor is the person who collects the assets of your estate, pays down your debt, and then files any necessary tax returns before making distributions to the beneficiaries. So your spouse may not be the one who you'd want to name as executor to have control over your assets. And if you had a will in place before you entered into this divorce process, now you might want to rethink that and change your provisions of your will to exclude your spouse as executor. Also, if you've established trusts for your children under your will, you may not want your soon-to-be ex-spouse serving as trustee and controlling the money meant for your children. With regard to financial powers of attorney, Pennsylvania law provides that as soon as a person files for divorce, if the spouse is named as the agent under that document, then that designation is revoked and the spouse does not have legal authority to do financial transactions under the power of attorney document. However, a bank might not know that. So you would want to update your power of attorney document to name an individual other than your spouse to act on your behalf with regard to your financial affairs. Also, don't forget to alert your bank regarding an updated power of attorney document. You want them to have the old document on file and not have the updated document. The same goes with healthcare powers of attorney and living wills. Most people who are involved in a divorce proceeding do not want their spouse or ex-spouse to be the one making healthcare decisions for them. So the best course of action is to have new healthcare directives prepared and to name someone in those documents who you trust to make healthcare decisions for you if you can't.
So Laura, for those of us with minor children, what should they be thinking about when updating the estate plan?
Well, one of the most common questions I receive from clients is whether a person can prevent their ex-spouse from being guardian of their minor children if they die. So generally, the surviving parent is a legal guardian by law, but there may be reasons why a surviving parent is not fit to serve as guardian of the children. In a case like that, the court will decide what is in the best interest of the child, but it's important to express in your will who you would want to serve as the minor child's guardian. The court might take your wishes into consideration. To protect any assets that would be distributed to young children, you might want to include a trust in your will. So the trust is a vehicle that would be funded with your assets, and distributions to the child would be made maybe at certain ages or at certain milestones. You would have to appoint a trustee who would be responsible for managing the money and for making distributions as well. So that would all go in your will, or it might go in a standalone trust document. And be aware that under a property settlement agreement, there might be a trust that's required for the children's benefit. and any life insurance payable in your life would then be distributed as a part of that trust. But speak with your estate planning attorney about that.
All right, can you talk a little bit about assets like beneficiary designations for life insurance policies and retirement accounts and things like that?
Sure. As the divorce process is coming to a close, it'll be important to update beneficiary designations for life insurance policies and retirement accounts. In fact, it may be mandatory to name certain individuals, such as your children or trust for their benefit, or even your ex-spouse as beneficiaries of those assets pursuant to the property settlement agreement, which, Drew, you had mentioned right in the beginning of this session. So a lot of times I get the question, can changes to beneficiary designations be completed before the divorce is final? Well, for some assets, the answer is yes. And for other assets, such as 401ks, the answer may be no without your spouse's consent. So you'll need to consult with your family law attorney and your estate planning attorney to see whether you can change the beneficiary designations for those accounts.
All right. And then one final question, Laura. Can I just get form estate planning documents off the internet? I mean, do we really need all these lawyers?
I get this question a lot, and by the end of a divorce proceeding, of the divorce process, I think a sense of fatigue sets in, and the estate planning attorney is probably the last person that an individual wants to go to see and talk about these issues. I know that a number of websites offer basic estate planning documents for a fee. My experience has been, though, that those forms may not comply with your state's requirements for valid documents and may cause more harm than good. Recently, and I had an individual come to me and she showed me a power of attorney form that she got off a website, and the website stated that that form would comply with Pennsylvania law. But when I took a look at the form was invalid under the new Pennsylvania law and was actually worthless. Another thing to consider is that internet forms will not have provisions that you might need to include in the document to comply with a property settlement agreement. So my recommendation is to consult with your attorney or an estate planning attorney who has experience dealing with estate planning matters so that your documents are done right.
Thank you, Laura. Very sound advice indeed. I want to turn it over to Valerie now. Valerie, can you introduce yourself, please, and tell us a little bit about what you do?
Hi, my name is Valerie Clark-Roden of Hoteling Investment Management, and it's been a pleasure to be in these series of webinars. Laura, I have to tell you, that was really thorough, and that sort of goes, I'm sort of right in front of that too, because we work with a lot of clients going through this transition, and you know, a lot of that has to be done. Thank you so much for sharing that very valuable information. So we're investment managers in downtown Wayne, and a lot of our clients come to us at this stage of divorce, you know, the post-divorce time when they're seeking ways to get their finances in order and to start their new lives. And after all, so much has changed for them, and now you have control of your assets as a divorced person, and they're yours, they're separate from your spouse's. So it's imperative to create a plan to get these assets working for you through your retirement and beyond that. First up, it's time to do some financial housekeeping. Update your accounts. If you're a woman and you change your name back to your maiden name, you're going to need a new social security card, driver's license, passport, credit cards. And if you're separating jointly held assets, that means assets that you had in a joint account with your spouse, you're going to need to open investment and bank accounts in your single name. And this is where we come in. As investment managers, we invest assets for our clients by creating customized investment models where we use traditional and quantitative research tools while we adjust and modify to align them with our economic outlook and our clients' life stage and their aspirations. In order for us to assess this and your overall financial assets and liabilities, we'll pair you with our financial planner. And with the help from a planner, you're going to be able to identify your cash flow, income, expenses, liabilities, such as loans, mortgages, credit cards, student loans. If your settlement includes alimony, pension rollovers, maybe proceeds from a vacation house, or a court order, which you've heard before from Drew and Sheila and many of, and Bill, it's called QDRO, which is a Qualified Domestic Relations Order, which divides your 401k or any other retirement plans. This is where a planner can take all of these into consideration while creating a way for you to live through your retirement and even possibly leave your loved ones with some kind of legacy. So to get the plan to work most successfully for you, we'll invest your assets according to your financial plan that has been created. So your investment assets can grow, or you can have your investment assets yield income for you. It just depends on what your established needs are, what you've established in that plan. So how about insurance? Auto, home, life, health insurance. This is equally important, and you're going to need to address this too. And Allie Collier is going to talk in a second from JKJ Insurance, and she's the expert in this field, and this is something that needs to be changed too. I'd love to meet with members of our audience to talk with them more about wholesaling investment management and what we can do for them at this stage. Give me a call, and you can find my contact information on our website, uncouplingphilly.com. Thank you.
Thank you, Valerie. Allie, I want to turn it over to you. Can you introduce yourself, please, and tell us a little bit about what you do?
Hi, Drew. I work for Johnson, Kennel & Johnson as an insurance account executive. We're a broker, so we are able to tailor insurance to specifically meet our clients' needs rather than a one-size-fits-all approach.
Okay. Allie, we've talked in previous webinars about when it becomes appropriate to separate insurance between the divorcing couple. Can you recap that for us?
Sure. It really becomes appropriate when they separate physically. One of the parties moves out of the shared residence. Another trigger may be when they purchase property outside of the marital estate or in one name only. So, they may still be cohabitating, but you purchase a, vacation home at the shore only in your name. That's not considered part of the marital estate. That's another time to look at dividing the insurance. And many times this occurs during separation where one party moves out, prior to the finalization of the divorce. But sometimes it doesn't. Sometimes they don't physically separate until right before the divorce is finalized.
Okay. Now, once the parties have their own insurance, what typically do you see next?
Well, many times people tend to go back to things that they loved prior to marrying their ex to, find some of their old hobbies or interests. So if the wife has a love of art and oil paintings that her ex did not share, we may see her purchase a piece of art that she always wanted. Or, and this is a true story, maybe the husband trades in the minivan for a Ferrari.
Sounds good to me. So why is it important to their personal insurance?
Well, the same insurance company that's good for insuring the minivan doesn't necessarily have the ability to properly protect a Ferrari, or there may be limitations under a typical homeowner's insurance policy that can't replace that oil painting if it's insured under, the typical coverage and not scheduled separately. And not every company even offers the ability to insure fine arts. So, sometimes you get an insurance agent who just makes the change on the policy. It's very transactional thinking. They may just congratulate the wife on the purchase, but not talk about ways to actually cover the purchase. So it's good to keep in mind that there are hundreds of different personal insurance companies, and every single company has a different target client and different products that they offer. So make sure the person you work with has the capability to offer coverage for your Ferrari at full replacement cost, or the ability to insure that fine art for no deductible and including breakage. So not all agents are able to cover it or even familiar with those markets. So make sure to find someone you trust who has experience with similar clients. Reevaluating your insurance program after divorce is a great time to make sure your coverage meets your changing needs but still remains affordable.
All right. Thank you very much, Allie. And last but certainly not least, we're going to turn it over to Liz Butler. Liz, can you introduce yourself and tell us what you do?
Hey, I'm Liz Butler. I'm a psychotherapist in private practice. I practice over in the main line as well as in the Chestnut Hill section of Philadelphia.
So, Liz, life after divorce, from what I've seen, oftentimes includes new marriage for those who are not so jaded to enter back into marital bliss. Can you talk about some of the challenges inherent in remarriage?
Sure. New love, it's great. Offers a new beginning. And it can be great. We've learned from our past mistakes and what the pitfalls were in the last relationship. We're a little older and wiser. So, hopefully we come into a new marriage more set up for success. Unfortunately, though, the bleak statistics say that 68% of second marriages fail and 72% of third marriages fail. But there are a bunch of things that couples can do to put the odds in their favor. Number one, do not rush into getting remarried. You've gone through a divorce. Divorce is never fun. It's almost always difficult and draining emotionally. So give yourself a lot of time to heal and settle into, your life as a single person, as an independent person. Build that autonomy. Two strong, independent people really make for a good, stable marriage. Another thing that is just a really good idea, and it's not because I'm a therapist, it's true, get into premarital therapy. People think of therapy as something to do when there's a crisis. Absolutely wrong. It is much easier to avoid a crisis than get out of one when you're in it. So be smart. Go talk to a therapist. Share with the therapist and your new spouse, what the pitfalls were for you in your previous relationships. Tell them what you've learned about, where your vulnerabilities pop up in intimacy. Be honest with them and invite them to be honest with you about their weaknesses about being in a couple and what they've learned. This is a really good way to troubleshoot and for each spouse to be sensitive to, troubling areas in the future. A good therapist will also spend lots of time talking about the strengths that you guys have as a couple, and that's really important too. Also, a therapist can help you to talk about those dicey areas that need attention, like money and household responsibilities, religion or faith practices, co-parenting, and the more clarification with expectations, the better. Finally, avoid the delicious temptation to ex-spouse bash. Super fun. It's really good to be, joined with a shared enemy, but really, it keeps the spouses joined to each other through vitriol. It's almost like you're still married to your ex-spouse, but the binding emotion is hate rather than love. The goal is really indifference and not having much attachment to the ex-spouse. So try not to indulge in that with your new spouse.
Okay. Now you mentioned children a little bit. Can you talk about blended family issues? I'm interested in your recommendation for step parents. This is something I see very often as a family law attorney come up.
Sure. Blended families can be joyous and wonderful and challenging and difficult. The role of a step parent can be confusing and non-intuitive. A lot of people come into getting remarried. You're so excited about your new relationship. We kind of have this wish and fantasy that we're going to be the Brady Bunch, where the new adults are welcomed into this brooding or this happy brood of children who all love each other and who are best friends. And this commonly does not happen. I have seen families that create a wonderful new family system with lots of love and new and enriching relationships, but again, clarity with regard to the appropriate roles of all of the above.
What should the role be for the step parent? I know they're certainly not to take the place of the real actual parent, but they are kind of like parents, aren't they?
Well, yes and no. The most important guideline I can give a step parent is that they need to assume a role of benign authority. The policy setting between the parent and the child really needs to lie squarely with the biological parent. This is what you have to keep in mind. The spouse chose you, not the kids. They kind of didn't have a choice in it. They may have been clued in, but they were, you've been kind of imposed upon them. And their mom and their dad had their own set of policies that were set before, and the parent is really obligated to maintain those policies, not your parenting values. Your role, the step parent's role, is really that kind of as a caregiver when the parent is away or busy. You want to implement their rules.
So you're telling me that a step parent has no influence on how the household is run? That seems a little unfair, doesn't it?
Well, yeah, I can see where you'd say that. That's understandable. But I'm really quick to add that the step-parent has this really wonderful opportunity to have a unique and loving role that can be extremely influential with the step-kids. You know, here's the deal. As parents, we try really hard to separate our own self-esteem from our children's accomplishments, but it's really hard not to feel, you know, really proud when they do well or like bad parents when they don't do well. Step-parents aren't encumbered with that responsibility. They really have much less of attachment to the success and failures of their stepchildren. So they are really free to join with them in a relationship where they can be a trusted mentor with no strings attached. Step-parents also have the opportunity to be a great support to your spouse in terms of insight into their parenting and their children. So you can be like this consultant to your new spouse about their parenting, but not the dictator. It's kind of like if they come to you with a problem from work, you would listen, you'd take interest, you'd offer them some insight, maybe some hard advice, but you'd never go in and talk to their boss or try to problem solve with a colleague. You would just offer support and be an advisor. That's how it needs to be. That's what the step-parent can offer their spouse. Now there is one big exception. When your personal rights are being affected by your stepchildren, then you have every right to speak up. Speak up to your spouse first, and then speak up with the kids. So if your stepchildren are using your computer and or leaving their stuff all over a common area like the living room, you have every right to say, look, I need you guys to clean this up, because those are your rights. So the question you need to ask yourself is, whose problem is it? If the answer is not me, then you need to move on.
So let me throw this at you, because I've seen this come up. What happens if both parents bring kids into the new marriage and the parents have different rules?
Yeah, that's really, really dicey. Can be tricky. So, for example, one parent might say it's fine that kids have TV in the room, and the kids may have had televisions in the room, and then the other parent's like, no way, no screens in the TV in the bedroom. So that's not fair, right? So the best advice I can give is a family meeting. Get everyone together and outline the problem to the kids and invite them to weigh in and engage in the process of troubleshooting. Parents are always surprised. The kids usually step up to the plate and offer good ideas. We expect our kids to just say, oh, I want it my way, and that's it. But when kids are asked and there's a problem that's laid out to them, they usually kind of get it. And they're touched and honored to be asked to help out, and they feel respected, which is always a really good thing. It's not always the case that the kids are going to come up with great ideas, but give it a try. I also remind families that families are not democracies. They're more like benevolent autocracies. Parents ultimately make the decision, but that should be after they've heard the kids out and let the kids express their needs and desires. When kids feel like they have a voice in shaping policy, you have much more increased compliance to whatever rules have been established. Look, and there's going to be inconsistencies, and that's life, and children need to be able to handle that, because we have to handle that as adults, so we want to help them to adjust to inconsistencies. So again, if you lay it out and say, look guys, this is how it is. I know it feels unfair. We're going to give it a try this way. No solution is final, and we'll reevaluate. Again, and you want to validate their being unhappy about it. And that's how it is. Yeah.
All right. Thank you very much, Liz. So that concludes our program. I just wanted to remind everybody that's listening, if you want to hear any of our previous teleseminars, they can be found on YouTube, on our YouTube channel, which is Uncoupling Philly Divorce Resource Group. And if you want to contact any of us in the group, you can go into our website at uncouplingphilly.com. Thanks again for listening.